cooperate with journalists, with civil society, with the judiciary, of course, because only if we all work together, I think, can we make real progress in the fight against corruption. And I think it's great that exactly these type of actors are the ones that you brought together here today for this discussion on Russian transborder corruption. Well, what I can say is that already within the European Union, obviously we struggle with cross-border corruption, and we have judicial cooperation somewhat established. And obviously it gets even more difficult when this involves third countries, particularly with Russia. I'm not surprising anyone here with some of the basic information. Of course, Russia is ranked 129th of 180 countries on Transparency International's anti-corruption, the Corruption Perception Index. We have a scale of corruption in Russia that's really quite baffling. What we have learned or seen again in the last few years from the palace that Putin has built on the Black Sea, the revelations of the Panama Papers. I think there are serious speculations that Putin might be the wealthiest man in the world, basically based on ill-gotten gains. And I think where it becomes particularly relevant for us as members of the European Parliament is that the EU actually plays quite an important role in this whole machine of stealing money, because our banks, our realtors, our political systems are somewhat involved in this. We have seen the investigations into the Russian laundromat, the Troika laundromat, and others that have revealed aspects of this broader system, and we see that our banks, our real estate market is involved. So I think, Ramona is going to talk in more detail about that when she speaks. But I think from an EU perspective, there are 5 areas that I would immediately see where we have to do more to contribute to this fight against corruption, including in Russia. First thing I would mention is that we need functioning beneficial ownership registers. We have made good advances on this. We are now on the 5th anti-money laundering directive in the EU, but this is not fully implemented, and the registers that are being built up in member states are not functional to a degree where we can really see who is behind certain shell companies, who is behind certain company structures that keeps buying stuff, including in the European Union. Second point, I think we have to better involve financial institutions, real estate agents in this fight. They need to do some of the checking. They need to alert the authorities when they see suspicious transactions or behavior. And I think there's more that we can do in that area. Third thing I would mention is we have to get much better at confiscating and checking illicit wealth. The UK is showing the way on how that could look like, and there's a lot of EU countries that are not quite up to speed on this, and we need to get much better in preventing that we are a safe haven for stolen money from the rest of the world. Fourth point I would like to mention is golden visas and citizenship programs, that we make it too easy in some EU member states for citizens of third countries, that if they bring some of their loot along, they get a passport or they get a long-term visa that allows them to freely circulate inside the Schengen area or reside in any one of the member states, and that cannot be, and also something we need to urgently address. And the last point, of course, is on the global human rights sanctions regime, or what we call our Magnitsky Act, I guess, that very unfortunately does not actually include corruption as a grounds for sanction so far. It's good that we have the sanctions regime now put in place, but our intergroup keeps to push and keeps to fight that transborder corruption can be a ground for sanction as well. So thank you very much for putting this debate together, and I'm very much looking forward to hearing from all the experts and engaging in this debate. Thanks so much.
Thank you very much, Mr. Freund, and I'm very happy to hear that indeed you also think it's not a matter of politics, but it's all about EU values. And it's also very nice to see that we now have a cross-party representation of MEPs here. So that's very telling. And I think the 5 points that you made are indeed the most important ones. On confiscation, I think we'll hear a little bit more from our next speakers as well, who have prepared the report, Ms. Kirilenko and Mr. Hummel. May I give the floor to you, Anastasia Kirilenko, to give a short presentation of the report, please. You have the floor.
Thank you for having me here and for everybody for joining. I'm a Russian investigative journalist working for The Insider investigative website, registered outside of Russia in Latvia. Since 2016, I joined working group on transborder corruption under the umbrella of the Netherlands Helsinki Committee. So to understand what is transborder corruption, this is very simple. This is when money is embezzled in one country, for example, in Russia or other post-Soviet countries, and then invested in the West, in Europe or elsewhere. As a journalist, I followed many symbolic transborder cases, such as Magnitsky Case or Spanish-Russian mafia cases. So we now have two bravest speakers on that. They will be the best on the topics. Just a few remarks. So recently there was an anti-corruption scandal published by newspapers called Open Lux, based on Luxembourg's beneficiary owners registry. The French Le Monde newspaper put it in the following way. We found hidden property of a certain Maxim Lalakin, whom Spanish prosecutor's office believes to be linked to mafia. This is great, but does it mean that only the Spanish prosecutor's office believes so? What is this Spanish phenomenon? So let me just tell a word about the mentioned Russian mafia case in Spain. In fact, there are many, but the most famous is the case of Troika or St. Petersburg mafia. So it started in 2008. Dozens of people were arrested. It was supposed that they laundered about 50 million euros in Spain. Many times Russia tried to get this case transferred to Russia for a better investigation. Finally, after having rejected several times such a request, the trial started in Madrid in 2018. Two defendants pleaded guilty themselves in money laundering. And guess what? The judges acquitted everybody, saying that they saw anti-economic transactions, strange transactions between Spain, Cyprus, Liberia, Delaware, Switzerland, elsewhere. But they received an evidence from the Russian FSB saying that there's no criminality and those people are innocent, as well as their bosses. On several pages, the Spanish judges describe how good the main defendant who failed to show up in court, how he is a good businessman and a shareholder of Bank Rossiya. Those people, they were prosecuted in Russia in the 90s, but strangely, the court acquitted everybody. They already, it was said in the indictment, you can find everything on our dedicated website called Transborder Corruption Archive. On the indictment, you can see that already they have German companies, for example, to transfer monies from extortion, etc. But everybody was acquitted. But the most tremendous in this case is that in 2018, the Spanish judges quote this 1995 Russian acquittal, saying, look, they were acquitted in Russia and we trust, we also acquit them. So everybody can read the Spanish acquittal probably with our comments in English on our website. We also collected many documents in Spanish, German, French, to create a kind of database to help to investigative journalists. For example, we were consulted recently by journalists working on Finsan leaks story, because they saw billions of Russian citizen Semen Mogilevich in UK, but he's not convicted, not prosecuted, and the journalists were looking at least for some circumstantial and other evidence, failed indictment, etc. on our website. We on our website we even have a report from Swiss intelligence. It was originally obtained by Jürgen Roth, investigative journalist in Spain, in Germany, who passed away from his sources. It is entitled Cooperation between FSB and Organized Crime from 2007. But it is good, and Western intelligence assumptions that mafia exists and big-scale corruption schemes exist, but it led to just a few convictions. Harry will speak more about it, but we describe how since 20 years many money laundering cases collapsed, because the main witness was killed in Switzerland in Sonsoskaya case. No witness, no conviction. In Magnitsky case, the whistleblower Alexander Perepelichny died. And by the way, in Magnitsky case, if I understand correctly, Mr. Browder will correct me, we have 16 probes opened in different Western countries and no conviction so far, only a settlement and a fine in US. So in Switzerland, I was given a comment by the prosecution. They said, it was a couple of years ago, they said that they studied a large amount of documentation from Russia to conclude the case. Strangely enough, it did not allow to conclude it so far, and this is it will be the anniversary 10 years after they started it, and probably probably they may even drop it. So I think we have a serious problem that in the state of rule of law, is it serious that the judges trust like FSB spravkas, FSB documents, and other legal help from Russia, or lack of this legal help is a real problem. Just to conclude, a detail from the biography of Mr. Bill Browder. In 2005, he asked for an investigation of an alleged scheme of embezzlement of Gazprom money. It was up to 478 million a year from Gazprom via infamous shell companies. So many journalistic investigations were written about it. Of course, no convictions. A man involved there is now a Minister of Justice of Russia. So also a man, for example, connected to the alleged mobster from St. Petersburg, but so on what the Spanish judges said, he is a good businessman, shareholder of Bank Russia. So his contact is now deputy head of FSB. It was confirmed by my investigations and also by iStories investigations of CCRP, and we are very preoccupied. And what could be the solution? Thank you.
Thank you very much, Ms. Kirilenko. I think you raised a couple of very important questions. Some of them were rhetorical. We will probably look at what we can do at the EU level as well at the second half of the presentation. I would like to give the floor now to Mr. Hummel to maybe share a couple of key takeaways with us from the report, and then we go into the two presentations by Mr. Browder and Mr. Grinda. Thank you.
Yes, thank you. Good afternoon, everyone. You know, if you look at the report, you will see that there are, you know, the first 6 chapters are an attempt and an overview to analyze and to review what has been done in terms of prosecution or attempted prosecution of people suspected of big time corruption and money laundering linked to this. And the overall picture is not optimistic. This is what Anastasia described, the legal means that the European Union countries, and this goes, I think, for other Western countries generally as well, have to go after the perpetrators of this massive corruption taking place in kleptocratic states are limited. Now, one answer to this, or the main explanation probably, is that the whole international scheme, what has been set up under international anti-corruption law and international anti-organized crime cooperation, works on the assumption that you can cooperate in good faith with the authorities and the prosecution authorities of any country, including in this case the country where the money comes from. Now, in situations where this state itself is rotten, literally, corrupt, this assumption does not apply. So you need to go and find other ways to operate. This can, go, I think, in different directions. One would be to look at the corrupt origin of the money and to try to document this in more detail. In the case of, the examples that we are looking at, this would mean not going through, beneficial ownership registers in European Union countries, but looking at beneficial ownership registers in Russia, or these countries, the origin of the try to document the corrupt origin of the money, and then use this in trials in European Union as evidence. I think probably this is an avenue that has limited possibility for success. It was tried with, and I think Mr. Proud will probably talk about this, it was tried with the funds deriving from the Magnitsky fraud case, where there was this type of information in quite some detail, but with very limited success in court cases, or even in the prosecution stage, where it was already not taken up or got stalled. The second main avenue to address the large-scale corruption and the way in which it undermines the European Union legal and economic systems is by looking at possibilities for non-conviction-based confiscation.
Harry, I have to interrupt for a second, because apparently we have a problem with the Russian translation, two interpretations going on at the same time. So I want to be sure that's fixed before we continue.
Не знаю, как эту проблему решить, потому что у переводчиков контакта нет друг с другом.
I can hear.
Okay.
Yes, thank you.
So non-conviction-based confiscation, which is something that has been legislated for under European Union law. There is a directive on this pretty long ago, I think 2014. There are some follow-up documents in the mind of I think most, and maybe even all, people working in law enforcement and financial oversight in the European Union. This is a scheme that is mostly directed towards organized crime, and then people think about the mafia in our own countries in the European Union, the people who live of drugs trafficking or of trafficking in human beings. Even within that scope, non-conviction-based confiscation still is very underutilized, in my view, as a way of, tackling people not by getting them criminally convicted, but by getting them stripped of their assets, which are criminally obtained. And, you know, in some legal systems, you can reverse the burden of proof. This is the case with the unexplained wealth order in the UK, where, you know, people with huge wealth, where there is no obvious source other than an illegal source, are asked to explain the origin of their money. Otherwise, they will be that those assets will be confiscated. The report describes, you know, in some experience that exists in the UK where they have gone in, you know, quite exceptionally after the assets of, you know, oligarch or people from oligarchic circles in Azerbaijan and in Kazakhstan who established themselves in London. There is mixed experiences with this route, but you know, the report tries to argue that this is a hugely underutilized method of you know, trying to go after you know, people who live of money obtained from kleptocratic regimes. And the overall, you know, picture is that you would need, you know, a different orientation, a different mindset, you know, both with legislators, with people in the law enforcement and prosecution sphere, and with the courts, different from what we have in most European Union countries and in most trials that have been attempted. There is, you know, several reports both at the European Union level and at the Council of Europe level that show that this can be done. There's also some jurisprudence of the European Court of Human Rights on this reverse the burden of proof issue, which many people may feel is, you know, contrary to basic human rights, that you are presumed innocent until you get convicted. The thing is that you are not convicted in this case. And as I said, well, the European Court of Human Rights jurisprudence does guide how this can be done. And, you know, the plea of the report is for this in the coming years to be taken up by European Union legislators and by European Union member state legislators and practitioners in this field.
Thank you very much. That's a very clear and concise oversight. We're a bit behind schedule, so I immediately would like to give the floor to Mr. José Grinda, who is an anti-corruption prosecutor from Spain. Mr. Grinda, you have the floor.
Hola, buenas tardes.
Good afternoon, everybody. I hope you can hear me well. I want to thank the European Parliament and the Netherlands Helsinki Committee invitation to speak or to try to give some tell something about our experiences and then what we had with the prosecutors. I'm from the Anti-Corruption Prosecutors Office. I'm going to try to be brief. I'm going to make my presentation in 3 parts. First, an introduction. Second part, in referral to the procedures in Spain. And in the end, I think the most interesting thing is to get a conclusion of all the impediments we see when we have these offenses of this corruption, of this laundry of money, and because the underlying problem is the organization, the criminal organization problem. Everything would be very easy if every country would use the Convention of the United Nations. If everybody would use it, there would not be any problem. The one from Palermo from 2000 against organized crime, and the one from Merida in reference to the battle against corruption. There that's all the cooperation we need, and we don't have now in many investigations when it comes to money laundering coming from criminal organization. The problem that we can have when if we see the title of this conference is that there are difficulties in the investigations, and they always have to do with countries that don't collaborate. And what means that? What does it mean, not collaborate? Not collaborate is not to answer, but it's also to give an answer, but put some impediments. So you say that you're collaborating, but in fact you're not doing it. There's a first frame or first obstacle, and that's the legislation. We, my former colleagues have said that there are also legislation problem in everything has to do with these two conventions I've mentioned. Everybody would be easier, but every country has its own legislation. There's a first obstacle and a first solution. We've talked about localization of real estate and the beneficiaries, the confiscation non-based on a conviction, and not really to put that somebody else has to prove something, but not if somebody cannot explain why he is so wealthy, then the proof hasn't been the other way around. But you only say you have too much of more than you should have. So it's not a presumption of innocence, but you have to be able to explain the origin of your asset. And this is something we can verify. We also have a legislative problem. When we have we talk about money laundering problem, it's an offense on its own. I will put an example: Switzerland. Swiss is a country that's giving us a lot of problem. They see a lot of money on their bank accounts, and it starts procedures on this. But when they ask for information, like to Spain, they ask the information about a procedure they have started because they want it about an offense of money laundering. When you give the information, they don't think it's good enough. So somebody in Switzerland has got a lot of money on a bank account, and they ask Spain to tell them where the money is coming from. And Switzerland says, no. Swiss says, or we tell you exactly where it comes from. Okay, the criminal organization should be the one providing the money, otherwise there's no laundry. So in Switzerland, they legitimize all this money from money laundering because they have to connect it to some delict. That's why I talk about this. The countries don't collaborate. Some countries don't collaborate. Some institutions don't collaborate. And there's a Spanish procedure. Some reports have been legitimized. They're coming from Russian institution. That's not a problem because we have reports in the same procedure that Ms. Kirilenko named, and according to which these people were being prosecuted were part of criminal organizations. I will extend a bit later on it. The problem is if the institutions aren't reliable of a country, if an institution says nowadays A and later on B, we cannot trust them. On the third place, a big problem in the collaboration are the non-extradition. The Convention of 2003, anti-corruption, and also the one from 2000 are very important conventions. They oblige you to extradite a person, and if the country that is not extraditing, and the country does not receiving the people can get a lawsuit. And what happens? That many times those extraditions are not allowed, but there is no procedure or alternative procedure in the country that doesn't give the extradition or allow the extradition. Sometimes formally there is this procedure is doable, but they don't do it. So I will stress that we need to do it on this alternative extradition and procedures. The country that is asking for the extradition should intervene in the procedure. So if Spain is requiring a person from another country and that other country won't allow that extradition, then Spain should be able to intervene in that procedure. And when it comes to the procedures in Spain, in concrete, with those that have to do with the origin in a criminal organization on Russian territory or from Georgia, for instance. We have had the collaboration almost completely from Georgia. It is so easy to collaborate. It's so easy as we had also collaboration with the police and the national police as the Catalan police. In Catalonia, there's a lot of migration from Romania and in concreto people coming from criminal organization. Romania organized, Georgia collaborates, Romania also, and Russia also. We have had two procedures in Spain, one against Hasan Salakov, a leader of a Russian criminal organization, and also another leader from a criminal organization. And in both, Russian authorities have collaborated. But we have had this Troika case that Ms. Kirilenko said, and then Russia didn't collaborate. Russia had offered some procedures of people that being investigated, like Petrov and Traber, procedures in Russia, where these people were investigated because of being part of a criminal organization. But in 2018, when they were going to be convicted, they said no. They had never been members of a criminal organization. The same with Petrov. So first they said they were, or they were lying on the first place, or they're lying now, and they are part of a criminal organization. It's a problem of legitimation. Institutions cannot be incoherent because the country will lose, won't be reliable anymore. So they contradict themselves, these institutions, and we don't know what is true. There's not enough transparency in the collaboration with the Russian Federation. When we had the problem in the Troika case, we had a level of leaders of the criminal organizations, and they had all gone. And we had a second level. If you, we have a procedure of and the leaders aren't present, it's very difficult to get them judged. And that's where they were acquitted, because those persons were on a very low level. But different institutions of Russians said they were acquitted, but it's not true. In Russia, they say they were acquitted, but that's not the truth. We have other examples. We have had a procedure against a man, and his name is Firtash. But we didn't have any collaboration from the other Russian authorities and also from Austria. And when we come to talk about problems we have, the lack of transparency and the collaboration of institutions where these criminal organizations are settled, I would make a distinction. Let's put an example. Italy and Russia. The Italian authorities are the first ones who ask for collaboration to fight their mafia, their camorra, their Italian criminal organizations. They won't put any problem. When we talk about Russian mafia, they say, no, there we already have the first problem. No, it's not mafia, the Russian mafia. Yeah, it is. But the big problem is that the Italian authorities always ask for the collaboration. How many times have you ever received a collaboration the collaboration for Russian mobsters or criminal organizations? There's one person that's known as a very big criminal, but somebody in Spain has been prosecuted by the Russian authorities. There was a red notice in Interpol, and he was asked to be detained. But that's all we got from Russia when they prosecute their own mafia. So we need more transparency with the institutions that are fighting this, and more transparency in the public registers. We have to be able to get from other countries access to the registers in Russian. But if the country itself is not transparent, it's difficult for us to access to that. We need a revolution in Interpol. It's not acceptable what they're doing. It's unacceptable. Interpol has taken off the international detain order of Petrov, and they're also pretending to do that with other people that are looked up to be convicted to 14 years. It's like Interpol, it's not aware of the seriousness of the criminal organizations. There has been a demand, and Interpol don't want to be prosecuted itself, and so we want them to be more efficient. They cannot exclude a red notice or many red notices because they consider that they can get into trouble. That's not the way they should work. The General Secretary of Interpol It's not right that they're afraid. Why don't they prefer, or why don't they intervene when it comes to criminal organizations? They only look at themselves. They don't look at how efficient they can be. And another problem we found, we also have another instrument of convention, but it's used not in a good way. The Russian there's something. Sorry, can you? Oh, they were all acquitted. Well, all these criminals were. They asked to transfer the procedure while all the proofs were in Spain, but in Russian they had the persons because they were there hiding from the Spanish justice. And they have had a procedure with no any guarantee that they had done any investigation. We have a sentence of or resolution of a court of Spain. They ask Russia to explain and to get the file of investigation of Purin, and we consider him a leader of a criminal organization, and it's sent to Russia, and we don't know what happened with it. With that investigation. And when we use the conventions to commit fraud, then we take all the legitimation of all the organizations away.
Thank you very much. It's a very difficult procedure and story you have shared with us. Probably a number of solutions, both at the legal level and at the practical implementation. And I have the feeling it can only be solved when you take an EU-wide approach. So that would also be an interesting question later to the members of the European Parliament. We're a bit behind schedule, so I would like to give the floor to Mr. Browder, and would like to ask you as well if you could limit yourself to about 10 minutes, if that's possible. Thank you very much.
Thank you for the invitation. And it's very appropriate for me to be speaking after Mr. Grinda, because my experiences in the Magnitsky case are real life examples of all the deficiencies and challenges that he has pointed out in his own experience as a prosecutor. Just for those of you who don't know me, I was the employer of a lawyer named Sergei Magnitsky in Russia. Sergei Magnitsky uncovered a $230 million Russian corruption scheme. He exposed it. In retaliation, the Russian authorities arrested him, tortured him for 358 days, and killed him on November 16, 2009. And I've made it my life's work since his murder to go after the people who killed him to make sure they face justice. And my campaign has taken on two forms. The most widely known form is the political campaign to get Magnitsky Acts passed across the world. The Magnitsky Act is legislation to impose visa bans and asset freezes on the people who commit gross human rights abuses. And I'm proud to say that after 11 years, we now have 31 countries that have Magnitsky Acts. The United States, Canada, the UK, and most recently the European Union, 27 EU member states. And there are various people on this call today who have been instrumental in that process, and I'm grateful for your support. I also wanted to reiterate one point that Daniel made when he introduced the call, which is that the EU Magnitsky Act at the moment doesn't include corruption as it does in America and Canada and soon to be in the UK. And that's a big challenge, deficiency, and something we need to fix. The second part of my work is to find who got the $230 million that Sergei Magnitsky was killed over and make sure they face justice. And for the last 11 years, together with a team of investigators, we've been looking for who got the money. And step by step, leak by leak, investigation by investigation, we discovered that about 23 countries had received portions of that $230 million. And of those 23 countries, every time we found the money going to those countries, we filed a criminal complaint with the law enforcement authorities of those countries. And of those 23 countries, 16 countries opened criminal investigations. And from those 16 criminal investigations, I probably have a more battle-tested view of what works and what doesn't work in the world of criminal justice and what works in the world of prosecuting money launderers than probably anybody else in the world, because I've seen which countries operate properly and I've seen which countries don't, and I've seen where the deficiencies occur. And let me share a few examples with you. I only have 10 minutes. I don't have an hour, but this could, there's a lot, I've got a lot to share. One of the reasons I'm happy to be on the call with Prosecutor Grinda is because he's one of the good guys, one of the effective prosecutors, one of the people who has taken this case seriously and launched a real investigation. In contrast to the experience that I had in Spain, we filed a criminal complaint with the Cypriot authorities soon after we discovered money going through Cyprus, which was probably 9 years ago. And the first response that we got from the Cypriot authorities was, we've got to, before we decide whether or not to open a criminal case, we've got to check with the Russians. Well, of course, if they check with the Russians, they're going to find out immediately that they shouldn't open a criminal case, because the Russian authorities, and I should point out, I should say not just Russian authorities, but leading right up to Vladimir Putin, were recipients and beneficiaries of this crime. And so, of course, the Russians would say no to the Cypriots. And it was only fortunate that at the time that we were having this conversation with the Cypriots, they were begging for money, bailout money for their banking system from the EU. And it was only because of good work from members of the European Parliament that they leaned on the European Commission and various European governments to say that if the Cypriots couldn't investigate the Magnitsky case because of Russian approval, then that should be a big question mark about whether they get bailed out. And of course, the Cypriots then formally launched an investigation, although up to this day haven't prosecuted anybody. Another shocking example is Switzerland. Switzerland, we discovered about $20 million going to Switzerland, the money belonging in a large part to the husband of the tax official in Russia who authorized the illegal $230 million tax refund. So we were able to, the person who authorized the illegal refund, money, then we were able to trace the money to her husband at Credit Suisse in Zurich. And then we filed a criminal complaint. That money was frozen, so was other money frozen. About $20 million was frozen. And then amazingly, this year, about 10 years later, we receive a note from the Swiss prosecutors saying that they intend to return most of the money, not all the money, but most of the money. They're going to confiscate some of the money because they've decided some of it is of criminal nature, but they're going to release most of the money. And when we looked into it, it turned out that the most senior person in the Swiss law enforcement authorities, I should say most senior person from the police side, who was a Russian-speaking Swiss man, was found to have taken bribes from the Russians, specifically to scupper the Magnitsky case. He was fired from his job. He was found guilty in a court of law, and he admitted that the money that he was paid by the Russians was to scupper the Magnitsky case. And yet, in spite of that, the Swiss still intend to return the money to the most of the money to the bad guys. And then you've got a situation in the UK, which was one of the largest recipients of this money, where they refused over a number of years to open any criminal investigation. And it was very interesting because the person at the National Crime Agency who was responsible for this, who was the recipient of my complaints, eventually left the National Crime Agency. And he told me, after leaving the agency, he called me up, asked me to come to lunch. And he told me that He wanted to open a money laundering case, but he was instructed by his superiors, under no circumstances should they open a money laundering case. So if the UK and Switzerland are doing this, imagine what's going on in Latvia or Cyprus or whatever. I mean, it's really a shocking situation. And to make it matters worse, in order to prosecute one of these cases, as Prosecutor Grinda said, you need international cooperation. You need to show that there was a flow of money from the predicate offense where the crime was committed to the country where the money has accumulated, in order to then draw a straight line and say, and therefore this money should be confiscated and the people who receive this money prosecuted. And so all it takes is one link, one break in that link of the chain, and you can't prosecute a case. And if you got all this terrible corruption and bad stuff going on and bad conduct for different reasons in different places, it makes it almost impossible to prosecute a money laundering case. And so what can be done to fix this? Two very simple things. The European Union is supposed to be a union. And as a union, it shouldn't require that one country has to make a mutual legal assistance request from another country. There should be a central database, a central banking database that any prosecutor from any country can draw on to prosecute their cases. And the second thing, which has been referred to by Prosecutor Grinda and others on this call, is that the burden of proof should be reversed. And that was done here in the UK, where they came up with this unexplained wealth order, which says that if you have a bunch of money and you can't explain where the money came from, then in theory, the authorities can seize it from you. It's the same reverse burden of proof exists in the Netherlands and probably does in other European countries that I'm not aware of. But if those two things were put in place, if the evidence was available in a central system for all European prosecutors to gain access to, and if for them to be able to then draw on that to say, why do you have this money? How can you explain it? How can you explain all these suspicious transactions? I think that you would see the prosecution rates going up by 1,000%. And let me just finish off by pointing out one shocking statistic, which is that the Magnitsky case is probably the most well-ventilated, well-researched, well-investigated international money laundering scandal that's taken place coming out of Russia. I've devoted a decade of my life to it with significant resources. It turns out that the Magnitsky case, and as we were investigating, we discovered that Danske Bank was one of the principal conduits of money coming out of Russia. The Magnitsky case is a $230 million case. And what was revealed from the Danske Bank investigation is that there was $234 billion of money flowing out of Russia. So 230 million is 1/10 of 1%. And I mean, just imagine that. So 1,000 times the amount of money is going through is this whole thing, and we're the ones putting it all out there. We can't, we're getting stymied and roadblocked at every step of the way. And imagine 100 times or 1,000 times that amount of money has actually come out of Russia. That gives you a good sense for how big and bad this problem is. Thank you.
Thank you very much for what I think is rather a depressing story. It's a massive problem, but you also gave some very clear indications and ideas of solutions. And I think that the next two speakers can tell us a little bit more about how we can tackle this problem at an EU level. And perhaps we can also look at whether in the future the European Public Prosecutor's Office, for example, can get a role here, not just limit its activities to EU funds as it does right now. I would like to give the floor to Mr. Kubilius, who will look at the strategic importance of tackling this issue. And then afterwards, Ms. Strugariu will look at specific and concrete steps the EU can take to address the problems you have discussed so far. The floor is yours, Mr. Kubilius.
Yeah, thanks a lot. Thanks a lot. Really good to see all of you with whom we met before or whom I see first time. But definitely, well, first of all, thanks a lot for the report, which is really great. Second, well, I will maybe start with a small introduction of myself. You know, I am a member of European Parliament from Lithuania, and and I was in Lithuanian politics for 30 years. I was Prime Minister of Lithuania. And of course, when the question which you asked me to answer, the strategic importance of tackling Russia-EU transborder corruption, for me, I became also, standing rapporteur on Russia in European Parliament. For me, answer is very simple and very clear. First of all, of course, especially living in Lithuania, being in this, neighboring towards to Russia, country. Of course, we dream that Russia at some time will become democracy. That's why we created so-called informal forum of the Friends of European Russia, since we really are looking, into that perspective. Because, for us to have democratic Russia as our neighbor, it will mean, everything, security, stability, and so on and so on. And of course, it's very clear, what is regime is totally opposite to democracy. I will not elaborate, what is happening now and what we can see. We saw last year Lukashenko. Now we see how Putin is repeating and even becoming more brutal, perhaps. But one of the things which really is an obstacle for any kind of hopes about democracy in Russia is, of course, corruption. And what for example, FBK is doing, Navalny what is doing, trying to show what is the level of corruption, how the whole regime is corrupted. Is one of the ways how to fight for democratic change in Russia. Second, of course, Russian people needs to know how and in which way their money are stolen, and especially with transborder corruption, which we are discussing today. That is what they expect from EU, from Western democracies, really to be much more effective. And Russian people needs to believe that European democracies are able to investigate and punish those who are stealing those money. From another side, of course, we need to understand that those corrupted money, so-called dirty money, which I don't know all the estimations, but I saw, Atlantic Council estimations that around $1 billion US dollars, Russian dirty money are flowing, are somewhere, globally going around. Of course, we need to understand that those money are also used for hybrid influences in different, Western democracies, and that is where we need to be much more effective in fighting, and containing those influences. And of course, if we want to be of, much more effective assistance towards Russian people in their attempts to transform their country, we need, first of all, to clean our house. That's what we understand also in a very clear way. Now, what really, again, I will repeat that I consider your report as really very great. One of those who are showing reality, where we are now. On one side, quite, I would call, black picture, how ineffective and inefficient we are on the Western side, with criminal investigations of their transborder corruption. Yesterday we had one of our forum events, Forum of the Friends of European Russia, which we devoted to investigative journalism of Russia, Belarus, and Ukraine, with Bellingcat, with FBK people, and so on. And I don't remember who, but exactly said that one of the problems of Western attempts to fight against this transborder corruption is that some prosecutors in EU are still not able to understand that there is no rule of law in Russia, and they are trying to find the ways how to cooperate with legal authorities in Russia. And your report, of course, is showing in a very clear way, how unsuccessful those attempts are. Since really there is no rule of law in Russia, and all the attempts for cooperation with, on criminal investigation perhaps really is not possible. So, but optimism I see in that last part of what you are proposing in your report, on this confiscation of illicit, treasures or properties. And I think that this is really what is a way how we can become much more effective. I am not a legal specialist on some of the aspects, but I think that what really would be very much needed, it would be really good to see that EU would move with some kind of more centralized approach of how to use this instrument. Like with anti-money laundering, directives, the 5th directive is coming with exactly proposals to have more centralized approach on EU level. So the same could be done perhaps with that, confiscation, of the properties without conviction. But here again, steps forward would be done if on EU side we should see possibilities to have more of centralized approach, not leaving it just to member states. So really, we are looking exactly into some kind of those ideas when we are preparing our, report on EU policies towards Russia, where we are looking really how to make, those instruments which we are trying to use against, corrupted regime of Russia, against corrupted practices, against persecution of democracy, of human rights. So I think that we shall really look all together, all of us together in European Parliament, how to put some of those conclusions of your report to push forward some decisions which are really very much needed on EU side. So thanks a lot.
Thank you very much. And I think if there's one leading theme here, and that is that you can only solve this issue if you address it at an EU-wide approach. I think that's the main takeaway from your presentation. Thank you very much. Well, the last one is going to answer all the questions, I think, because it says, what can the EU do? So I'm very happy to give the floor to Ms. Strugario, and maybe you can also reflect a little bit on some of the ideas that we heard before. Mr. Browder mentioned the EU mutual legal assistance, whether or not that is possible, maybe the role of the European Prosecutor's Office, sanctions, other political tools. I'd be very happy to hear your views on that, Ms. Strugario. The floor is yours. And I have to apologize just a second that we had no Russian interpretation, and apparently we now have double Russian interpretation again. So maybe just 1 second. I think it's okay now. Is that correct? I'm looking at Ms. Kirilenko. Maybe is the interpretation back to as it should be? Just to have a short test. Yes. Interpretation is the floor is yours, Mr. Strugario. Apologies.
Thank you very much. Thank you for the invitation, for the excellent contributions. Also, we are, as a matter of fact, discussing and having this debate when the actual EU-Russia relations are at a historic low. Following the recent visit of the EU High Representative to Moscow in February, and now the recent statement of the Russian Foreign Minister, who was literally declaring the EU-Russia relations as dead. But nevertheless, even if we were not situate ourselves in this kind of circumstances, the money laundering schemes in this circuit of EU-Russia relationships are very old. Basically, and I have these figures in front of me, almost 21 billion euros in illicit funds were moved through bank accounts in Eastern Europe between 2011 and 2014 to the Russian laundromat. And a 2020 study of the ECFR, which is the European Council on Foreign Relations, revealed that in 2016, Russian citizens own as much as 60% of their country's GDP in offshore wealth. And this is a percentage that is only matched by citizens of the Gulf and Latin America. Of course, not all of this money is held in Europe, but some of it is. So I wonder to what degree EU member states are actually accomplices to these money laundering schemes. And I will explain immediately what I mean by that. As it was already mentioned, but it is, I think, important to mention again, only in the Danske Bank scandal, through the bank's Estonian branch, $230 billion were allegedly laundered by corrupt actors based in post-Soviet states through the non-resident accounts, using shell companies registered in Spain, Sweden, the UK, or other European countries. Even though at one point Danske Estonia accounted for about 30% of the country's suspicious activity reports, no European regulator noticed anything was wrong. So not only do we allow money coming from illicit activity to be laundered in the EU, but we also allow third country nationals, out of which many Russians, to obtain EU citizenship or residency through the citizenship by investment or residence by investment schemes. And last year in October, the Commission launched infringement procedures against Cyprus and Malta, as you well know, by issuing letters of formal notice regarding their investor citizenship schemes. Both Malta and Cyprus said they would revise these schemes, but they still exist in 19 of the 17 EU member states. Portugal, Greece, Bulgaria, Croatia, about 30,000 for residents. Luxembourg, about 5 million for residents. Very nice amounts. You know, these people are basically residents of the European Union, enjoying a comfortable lifestyle, while their illicit money is protected in EU banks. Portugal alone, to give you an example, about 20,000 residence permits have been sold since 2012, raising approximately 5 million euros. What can the EU do? That is the main question. First and foremost, we should finally get a common position in the Council, a very clear one, to establish a clear and comprehensive sanctions regime against Russian individuals involved in corrupt activities, which is easy to say but complicated to do. And yes, corruption should be included. I fully agree with that under the Magnitsky regime. But we still have governments, member states governments, who are literally benefiting from relations with such individuals. And in many instances, these relations are mediated by influential European businessmen. If you remember, a 2017 EU Observer investigation detailed how a German businessman organized a meeting between Prime Minister Orban and Sergei Kirienko, the head of the Russian state-run nuclear energy company, Rosatom, meeting which basically turned into a nice cooperation for the construction of the Pax nuclear power plant in Russia. As long as oligarchs and corrupt oligarchs from Putin's close circle continue to have close relations with high-ranking officials from member states' governments, and as long as these are tolerated by the EU, imposing effective sanctions is extremely difficult. A second thing that we need to do, as long as we have a critical number of politicians willing to do this, is that all member states who have citizenship or residency by investment schemes must abandon these practices that allow rich criminals to come and live a comfortable life in the EU, and most of the times buying the citizenship with money from illicit sources. Third, we need a comprehensive anti-money laundering legal framework, and we have seen how the directives evolved. They are slow to transpose. Nobody literally properly transposed the fourth anti-money laundering directive. Each member state, I think, had a different interpretation of how to transpose this. Now, on the fifth AMLD, only 19 member states have full transposition, and 7 member states, including Hungary, Poland, the Netherlands, Ireland, or Spain, have only communicated partial transposition measures, while Cyprus has not communicated any transposition measures so far, and the transposition deadline was January 2020. This is why I think the EU needs a regulation, an anti-money laundering regulation with a strong text, and that would probably allow us to follow the money. This following the money has a very high importance, but not only law enforcement needs to follow the money. Politicians need to understand that law enforcement in each and every of these countries is and has to follow this money. We must also have a clear and comprehensive list of non-cooperative jurisdictions for tax purposes. The Russian Federation is not on this list, not even on the EU grey list, in spite of the recent money laundering scandals. And finally, there's the question of impunity, and here the EU has fewer prerogatives, and it is up to national authorities to enforce the rules and pursue these illicit activities. But the national authorities will do that if they are allowed to do that, if we are in the situation of a true balance of powers and a real rule of law framework, which we do not have in some of these member states. And then investigating money laundering takes a lot of courage. And it also takes politicians who are clean and who are willing to create this framework of cooperation, of response, of well-trained authorities, of interoperable databases, because it was mentioned here, of reversal of burden of proof. And I just remind you this episode, that I worked in my technical capacity at the Directive for Combating Money Laundering through Criminal Law in 2018. And the majority in the European Parliament was quite a nice bouquet of people dedicated to the topic, and we were able to obtain an excellent text. That was one of my priorities and my team's priorities at the time, as a technician, not as an MEP, but my MEP was supporting it as well, to reverse the burden of proof and to have real sanctions for public officials involved in money laundering. Well, the problem was not in the European Parliament. The problem was in a small number of member states with a very powerful blocking minority for introducing these things that I just mentioned. And these are not those countries that you might think of maybe at the first. I'm not going to point my finger now, but those were the countries that you would expect less, and countries which have a very anti-corruption and rule of law kind of speech. So I think we still have a long road ahead, but as long as there are people in the law enforcement, and I'm happy to see some here, in the independent investigative media, and I really like to salute them, in the civil society, and even among politicians who are truly willing to do this. It is a bit of a guerrilla war, but this is the truth. We need to find each other and fight for that. I think we can obtain results, but we will not obtain them overnight, and we will many times obtain them against some political will, which doesn't make it less interesting and challenging. So thank you again. I hope that we will continue to do this and find more and more politicians also dedicated to the topic, because it is of extreme importance at European level and at national level as well. Thank you.
Thank you very much. Thank you very much also for highlighting these very concrete steps, and also the issues sometimes that you may want to do something at the EU level, but you're not able to because of certain member states, because very often we think it's the other way around, or certain politicians try to explain that it's the other way around, that it's Brussels blocking. But this is maybe an interesting topic for discussion as well. I don't know if at this stage any of the panelists want to react to what has been said so far. If not, I would like to open the floor for questions and answers. I see that we have one question already, and I think that Harry Hummel also indicated that he wanted to make a couple of remarks and perhaps take this question as well. If that's the case, I'll give you the floor, Harry.
Yes, well, two things then. One is this particular question, which was by one of the participants about the use by law enforcement and financial units of prosecution services and similar bodies of existing databases of drawn up by investigative journalists and civil society organizations. We, Anastasia and I have been talking about the Transborder Corruption Archives website, but there are a number of others, including one which I have not posted it in the chat. I will post it in the chat. I think that there is an issue of a large amount of information collected by civil society and by investigative journalists that is underutilized by the people who have the legal mandate to go after this type of corruption and money laundering. In many cases, I guess the type of information is not exactly fitting. It doesn't completely fulfill what is needed by law enforcement people. But I think that there is, a great potential for bringing these things closer together and for, having a closer contact and cooperation between the people on the civil society side and the people on law enforcement side. I will send it now. This particular website that the participant Galina Selig of Sealy in Prague referred to. Then my second point is a bit different nature, but I think it is important to make, and this is that I assume that for many countries, law enforcement and prosecution is an area where they see many shortcomings, and in a number of cases, quite some cases, probably the shortcomings are also in, providing security and providing rule of law to their own citizens, in relation to day-to-day events, violence, burglaries, what have you. And then, corruption committed in a foreign country can easily become deprioritized. In the case of the Netherlands, this has been discussed in Parliament a number of years ago, and it was agreed that the particular financial unit of the prosecution service who would have to investigate this would be the personnel would be increased quite substantially. Because the assumption was that much more money would be made by, confiscating the assets of criminals or criminal organizations that would be caught as a result of this expansion of this unit. And this has worked. Well, I will not go into details, not exactly in the way many people would have liked best, but the net result is clearly positive. So, if you talk about financing this type of work, and I think these considerations should be taken into account as well. In a bit similar way, I think even sometimes that civil society organizations could make money out of, denouncing corruption of people by starting civil suits and these kind of things. But that is even a step further. I think for the moment that it is important to recognize the financial and the sustainability component of the law enforcement and prosecution bodies of the EU and of its member states, and that this issue of how this can be financed should be on the table as well.
Thank you very much. Unfortunately, Ms. Strugariu has to leave us. Thank you very much for joining us, and thank you very much for your words. I am not sure if there are any other questions from the audience. I don't see raised hands. Maybe it's difficult to raise a hand or everything is clear. That's why I want to look once again in the chat, or if people want to take the floor, then now is the moment. And if not, that means that everything is clear. Then I would like to thank the authors of the report.
I'm
guest
sorry.
speakers. Yes.
Yes, it was a question probably for law enforcers. Would be this database of Russian politically exposed persons? Would it be helpful, or what could civil society do? In fact, but if because we have a law enforcer, Mr. Grinda, among us, if he can, or somebody else. Right?
Mr. Grinda?
Was it interpreted?
Yes, we have a slight delay because of the interpretation. Would you like to respond, Mr. Grinda?
Yes, the question was from the editors of the website Russian PEPs, Russian politically exposed persons. Their idea is to help, prosecutors in Europe. So if somebody arrives in Europe with a big amount of money, and then he's in the database that he is a State Duma deputy, local deputy, etc., is it helpful, this website? If not, what else could be done by civil society and investigative journalists?
Sí, sí, está entendido. Gracias. La consulta de base de datos...
To consult the database requires two things mainly. The first, it must be reliable. We have to analyze the origin of the information in the database, and also I will explain it a bit more. We need to know where the information comes from and who supports it, because this has to do with reliance. It can be analyzed here by the police or prosecutors, and that's a task that we should revise and check if we can do it, and we should develop it. And the second requirement is a bit more complicated. If there is an investigation in which we are involved as Spanish prosecutors, we access to a database. That access will be registered somewhere. It's not opaque. Somebody will know that we have accessed to search for after a certain person. So if we have secret investigations, we shouldn't access to those databases. When the case is public and everybody knows the aims of the investigation, we could access to those databases. But it would be in a progressive way we should do it, and the database naturally will be appreciated, of course.
Thank you very much. I think I see one final question from Halina again in the raised hand. Would you like to take the floor?
To whom is the question, sir?
Well, I see a raised hand from Halina Senik, who, yes, go ahead, please. You have to unmute yourself and then you can take the floor.
Okay, great. So basically, since the database, thank you, Hertha. It was very interesting what you said.
the database, and it's not the only one, they are popping up in different countries. For the time being, there are 8 national PEPs databases, and the idea of them is to collect information from publicly available sources, which are being verified, and every single statement in the database, and you can see it yourself if you take a look at it, is being supported by archived documents. I think that what was discussed today is some people mentioned the problem, others said that there is a need for new rules. I think the rules are there. There is no possibility to investigate predicative crimes in Russia because there is no cooperation from the Russia side. Moreover, as soon as you open any investigation which would involve confiscation of property in any EU country, most likely you will get a demand from Russia that they also have this investigation pending and they need this confiscated property. So I think that once there is a clear status quo that there is no cooperation and cannot be, or rather most unlikely there will be any cooperation with Russian law enforcement to investigate transborder corruption cases, then there should be a clear understanding within EU member states that they need to protect themselves from this process of corruption and not to harbor them. And for that, there is a necessity to create a clear tools of identification of origin of this process of corruption to the extent it is possible, and identification of politically exposed persons. I'm not saying that all of them are corrupt, God forbid not, but I think that tools like that would be really, really helpful. And the same is true about all the archived investigations which Anastasia Kirilenko's project was working on. They're also very helpful to establish a historical legacy about the crime development and to understand the structure of crime in Russia. And I think that these efforts, they need to be better promoted among those people who are working with these issues on a daily basis, because rather than creating new instruments or new legislation, there is more sense in trying to implement what is already in place. But that is my humble opinion, and thank you very much.
Thank you very much. Would any of the panelists like to react for a final thought on this before we wrap up?
Probably very quickly, we should of course promote our efforts, but in the same time to remain safe. The question of safety when we struggle against kleptocrats is important for everybody, including for prosecutors in Spain. I know that, so let's be glad about what we are doing, and let's see.
A very valid point indeed. I don't think I see any further questions. So once again, then I would like to thank the authors of the report, our distinguished speakers, and the audience for listening to us. We're only 10 minutes over time, so I think that's well done. Thank you very much once again. The reports are online. We look forward to keeping in touch with all of you and hopefully have a much more positive answer to the question, Mission Impossible, yes or no, the next time that we meet. Thank you very much and have a nice day.
Yeah, goodbye.
Bye-bye.
Bye.
Thank you. Have a great day.